In this video, I'm going to go over what the McClendon standard is. This is the standard that applies after there has already previously been a designation by the courts of a primary custodial parent. This standard does not apply in an initial custody case, and it does not apply when each party has joint legal and joint physical, and we're trying to modify them. Those are best interest of the child. So the McClendon standard, what I'm going to go over here is when we already have a designated primary custodial parent and we're trying to change that. This is the standard that the judges have to go by. So number one, you've got to prove that you are a fit custodian, that you're capable of taking care of the children. Number two, that material changes which affect the child's welfare have occurred. And three, that the positive good brought about by the change in custody will more than offset the disruptive effect of uprooting the child. So you can take care of the child, something has happened, material change of circumstances, and then three, that the positive good, the good that will be brought about, will substantially offset the disruptive effect of uprooting the child. That's what the law says. Okay. It's not enough to be the better parent. So a lot of times, the thing I'll talk about is a lot of times someone's mother-in-law may be a better parent, but that's not enough in order for them to get custody. Okay. Or let's say that in the divorce, the mom is the primary custodial parent. It's not enough that later the dad then becomes the better parent. That's not enough. Okay. That's not what this law says. In the initial divorce, it's the best interest of the child, which being the better parent may matter at that point, but that's not what matters here. This goes over again. It applies when one parent has primary physical custody. We've already got that designation. So what are examples that could meet that? Might be if a lot of times the way I'll explain it is that, like, in order to hit McClendon standard, you've got to basically prove the other parent is unfit. Okay, that's not what the law says, but the easier way, layman's terms to understand it, is unfit. Okay, so one might be relocation, that the mom has just picked up and moved to California. Okay, that might be a reason to change physical custody. Next would be abuse. Classic one would be if they're hurting the child. Next, serious neglect, such as serious medical issues and they need to go see a specialist and the parent doesn't take them to see the specialist. As a result, there's serious medical issues. Instability. If mom is moving from boyfriend to boyfriend to boyfriend to boyfriend, moving, not just having different boyfriends, but moving from boyfriend to boyfriend to boyfriend. These are some of the classic ways to show that. And the reason is the courts favor stability. If it just were once we have a designation and then dad gets a better job and we change custody, or we get a designation and dad's got a good girlfriend or dad's got something good has happened, we'd be changing custody back and forth, and that's not what's best for children. So courts have created this standard for stability. So here is the case that this was created in 1984. Here it shows that the grandparents had custody, then the mother got her. So there was a designation where grandparents got custody. Then the mother got things together, got her shit together. So after that, she then petitioned for custody. And this is what the court said. The court said that frequent disruptions are to be condemned. Although the best interests of the child are paramount, this is not the standard to be applied. It's important that they show the child's interests are promoted by the change, that she produce evidence to overcome the inherently disruptive effect caused by uprooting the child. So even in the case, they pointed out here that it's undisputed that the mother has remarried and is now able to provide a stable and wholesome environment for the child. So, for instance, if mom was on drugs and now she's got everything together, she's got it all. She's a good mom now. That's not enough. That's just one part of the standard. It's that plus there's been a material change of circumstances. Usually that's something on whoever the custodial parent has messed up in order for us to change. So this is the biggest thing about it is undisputed. The mother is remarried, is now able to provide a stable and wholesome environment for the child. She and her husband have one child of their own, have an income adequate to support both children. So they're saying she's a good mom. Mother's new husband has testified that he will help and that he wanted custody to be returned to her. And they agree that the grandparents can continue to have visitation. However, the court said that's not enough. it says that the positive good brought about by the modification must more than offset the inherently disruptive effect caused by uprooting the child. Frequent disruptions are to be condemned. And so the court said that custody was to stay with the grandmother. So if you've got any questions, let me know.